Today we're going to continue our series on estate planning with financial life planner Tom DeYoung and attorney Ethan Huizenga. Ethan, last time you mentioned 2 ways to divide your estate among your heirs. Can you elaborate on those 2?
Definitely. There are 2 ways that a court can divide your estate if you don't leave specific instructions. The first way, and the default rule in Iowa, is per stirpes. The second way is per capita. If your estate is divided per stirpes, it gets split into equal shares for each branch of your family. If your oldest child passes away before you do, their share gets divided equally among their children, and so on.
And how is per capita different?
A per capita distribution is where the heirs of the same generation each receive the same amount. A simple example might be where you have 1 living child and 2 deceased children. The living child gets 1/3 of the estate, and the kids of the deceased children split the rest equally.
That seems overly complicated.
I know, hard to believe, right? Per capita distribution has the potential to cause certain heirs to be treated unfairly, which is why Iowa, and many other states, use a version of per stirpes as the default rule.
Explain that default rule for our listeners.
So every state has a set of laws that apply when a person doesn't make certain decisions about what should happen to their property when they die. These default rules are called intestacy laws. They apply when you die without a will, but if you leave things out of your will, the intestacy laws will sometimes fill in the blanks.
Then the best way to avoid the complicated default rules is to decide how your property should be divided before you die and put that in your will.
Absolutely.
So what are some of the ways to do that?
The most common way is very simple. Leave instructions about dividing up your property. Decide ahead of time if each of your children should get an equal share. Decide who should get the farmland, or if the farmland should be split up between your kids. Make a list of items that should go to each of your heirs.
And you can make that list separately from your will, correct?
If your will contains the right language, yes. That's called a personal property memorandum.
Thanks again, Tom and Ethan. You're really sharing some interesting information here. Part 4 of our estate planning series will talk about the personal property memorandum and how to use it.